Hello, I'm Phillip Saunders. I teach here at the Schulich School of Law at Dalhousie and an associate in the Marine Environmental Law Institute. Before I begin the substantive part of my presentation, I'd like to take the option of doing a little bit of an introduction. My association with the program, with the Marine Environmental Law program, and then later the Institute, goes back a long way. Maybe I'll go a little bit over what we've been advised to do, but I hope I get some leeway in that. My initiation into the Marine Environmental Law program at Dalhousie began when I started first year law in 1981-82. I had just returned from Botswana, where I had been a district officer in the government service working in rural development in the Kalahari Desert, a long way from any ocean. But it didn't take long to find out that the Center of International Law Studies and a lot of the most interesting environmental and interdisciplinary work was being done in the marine and environmental law area. I was fortunate enough in first year to be taught contracts by Norm Ledelick. Norm, well, in addition to teaching, was working at what was then the Dalhousie Ocean Studies program, which involved all of the same people as MELP, and he was kind enough to hire me as a research student, beginning during the year and then in the summer, and assigned me to work with Douglas Johnston over the course of the summer in particular. I arrived, or began my work at DOSP, as it then was, and was amazed at the welcome, at the quality of the people, the number of people involved at that time. There's John Gratwick was around from the transport side. My primary contacts were with Douglas Johnston and Edgar Gold, Art Hansen, and a group of students and researchers who've remained an influential part of my life ever since. People like Dave Vanderswag, Ted McDorman, Peter Underwood, sadly passed away a few years ago. Later, Aldo Chirkop. All of these people were a part of a community that was extraordinarily welcoming, and to me, engaged in very exciting work of an interdisciplinary nature, which I think was well ahead of its time in legal studies in that era. I was fortunate to continue working with MELP throughout law school, and was hired as a research associate for 1 year when I finished law school. What struck me most about that period, I mean, there are a number of things that did, and it certainly set me on a career path, but it was the fact that you had people of extraordinary talents. And I looked at the varying backgrounds of people like Doug and Edgar and Art, quite different in the expertise and the insights they brought, but all nonetheless capable of working together and extremely respectful of each other's viewpoint and the perspective that they brought to this area of study. It's a lesson that I've tried to remember since, and certainly when I went to work after leaving the Ocean Studies program, I went to work at the then new International Center for Ocean Development, worked in the Caribbean, Southwest Indian Ocean, South Pacific, eventually going on to set up a regional office with marine programs in the South Pacific. The work that I originally did at MELP was at the heart of everything that I did in those later years. So I owe a great debt of gratitude, first to Norm for actually hiring me, and then to everybody else who made it so easy to fit into that environment. Now, it's a little difficult to pick a topic that's satisfactory for both the time frame and the scope of the period that we're talking about, but I decided I'd like to turn to perhaps a theme is the best thing to call it, something certainly that Doug Johnston used to think about a great deal, and I know he wrote about this in later years, is the conflicts and the transitions that were involved in the law of the sea as we moved from a period in which the primary, but not the only, concern of legal development at the international level was with the establishment of jurisdiction, jurisdiction in different forms, who had jurisdiction in a plenary sense over coastal waters extending out to some distance off the coast, who had jurisdiction over shipping from an international organization perspective. What were we to do with high seas fisheries and high seas environmental issues? All of these were approached principally and initially from a jurisdictional perspective because of the huge gaps and conflicts that had not been settled. And the development of the law of the sea was a triumph in many ways in accomplishing much of that work. And on the other hand, in later stages, as Doug and others pointed out, the development of management principles, the how we go about managing ocean spaces as opposed to the who gets to manage them, became more and more important over time. And the issues of continuity and the value of continuity in the law of the sea and the capability for adaptation in the face of new problems, in the face of management challenges, in some ways unanticipated, has been a continuing one over the years, and one that I want to talk about using primarily one example that I'll come to in a moment. Now, when I began at MELP as a student, of course, that was 81-82, so the Law of the Sea Treaty, concluded in 1982, was undoubtedly the most ambitious multilateral and multisectoral treaty attempted to that point, not just in the marine sector, but more broadly, I think. And to some extent, the negotiating structure and the template for how they went about creating even the possibility of negotiating such an ambitious document was used in subsequent efforts such as in particular, the Rio-associated treaties in the early 90s, climate change, desertification, biodiversity. But it's still very clear that the Law of the Sea Convention, though it's a transition into that period, was of a different era and had not fully adopted, at least explicitly, many of the principles that emerged in those later discussions surrounding the UN Conference on Environment and Development. Now, some of the key characteristics, and this is very broad brush obviously, but one of the key characteristics of the Law of the Sea Treaty is, we were confronting it and trying to understand it as other people had been working with it for years and were up to their neck in the negotiations. As students were quite excited to be at what we saw the cusp of the development of international law in this area. But there are a few things to remember. First, the clarification and codification of jurisdictional entitlements was a massive accomplishment and central to the treaty structure. The clarification of the breadth of the territorial sea and the nature of the obligations within it, codification as well as some advancement, the acceptance and development of the exclusive economic zone as a compromise between the various jurisdictional entitlements that were being asserted beyond the territorial sea, an agreement on the scope of the extended continental shelf, perhaps a little more optimistic about what that agreement actually concluded, given the work that's had to go into it over the years since, but nonetheless an agreement on the principles that were to be applied. All of these were things that had to be done. If you cast a mind back to things like the Cod Wars and other conflicts that had gone on in the immediately previous period, that in itself would have been a pretty substantial set of accomplishments for a major multilateral treaty like this. But it also tried to go beyond, leaving aside the deep seabed, which I think is a somewhat different issue. You saw the attempt to impose obligations as well as these setting up these entitlements to jurisdiction. Obligations with respect to conservation, environmental protection, responsibility for the actions of your flag vessels, a whole range of things. But I think it's fair to say that by and large the obligations were less concrete than the creation of the entitlements to manage. And as we'll see later, many states adopted the obligation, or the entitlements rather, more enthusiastically than the obligations. The next point I just make generally is, despite the attempt to be quite broad and despite the inclusion of some fairly general marine environmental sections, outside the jurisdictional entitlements there is a strong sectoral focus. So there was the attempt to make more complete and concrete the plenary jurisdiction of states over certain areas in their coastal waters. But beyond that, and even to some extent crossing over it, you had a sectoral focus. Shipping provisions, there were living resource provisions, pollution and marine environment provisions, marine scientific research, and on. So it's natural that it was, and I think necessary given the way these industrial sectors are managed, but it's an important structural point that in later years has come to be something that has had to have been reapproached as to how we accomplish an integrated approach to management when we're dealing with essentially a sectoral development and division of the law. Finally, just note the reliance throughout the treaty, particularly in those parts where agreement was not as complete, on the further development of the law through competent organizations such as the IMO, for example, but also through other means, references to further diplomatic conferences. So areas that were recognized as not being fully settled, high seas fisheries, for example, straddling stocks, were seen as something to be pursued further in later legal development. Now, jumping ahead, if we move to post-Law of the Sea, and not really that long a period from the conclusion of the agreement, but fairly long period from when a lot of the substantive negotiations in the Law of the Sea took place, we had the UNCED process broadly defined, culminating in Rio in 1992, which some would argue, and many would argue, went in a somewhat different direction, building on principles of sustainable development that certainly predated the conclusion of the Law of the Sea Convention, but developing it in a more defined and categorized manner with a number of principles that were seen as critical to environmental management and sustainable development writ large. Particular principles that acquired real prominence at this point: the precautionary approach, of course, or precautionary principle, depending on your taste. The notion of integration and a more holistic approach to management, reflected as well in the argument for the ecosystem approach. Additional principles related to the importance of public participation and traditional knowledge and the implementation of traditional knowledge. All of these were principles that had echoes from in the Law of the Sea Convention, were not explicitly provided for, and in some cases would be quite difficult to reconcile with some provisions in the Convention. And the reconciliation of the two broad approaches has been an ongoing process ever since, something that Doug Johnson and others picked up on very early, that we had made a shift in legal approaches, but we still had a very significant and still evolving or still being completed treaty in the form of the Law of the Sea Convention, and reconciling those two was going to present some challenges. Now, the example I want to return to later on, it relates to how we've accomplished that process, or how far we've gone with respect to the fisheries provisions of the Law of the Sea Convention, and in particular fisheries provisions that where there were gaps, such as highly migratory species, high seas fisheries, and straddling stocks as well. And how the fisheries provisions now are going to be able to adapt, the fisheries elements in the Law of the Sea Convention can adapt to the challenges, which we'll talk about in a little bit, presented by climate change in the fisheries context. Just as an example of how well the convention, the 1982 convention, is suited to adaptability, to change and evolution over time. To do that, I want to go back just for a moment to general effect of the fisheries provisions of the 1982 convention. Remember that the big battle then was just to get jurisdiction over the fisheries off your coast. When I was first in university, the big argument was to get some kind of jurisdiction out to potentially 50 miles and to have a zone closer in where you would have a preservation of the fishery for small-scale coastal fishing interests. And there was some work done out of the law school, I believe under the supervision of Chris Axworthy, and my brother actually worked, giving advice to fisheries groups on trying to accomplish that. So we were well away from the notion of a 200-mile zone. But the convention did accomplish that, coupled with state practice that was rapidly moving in that direction in any event. But it did other things as well. It endorsed conservation, certainly, although the primary concern was to establish jurisdiction, which it did. The jurisdictional entitlements, therefore, like the broader analysis of the convention I suggested before, the jurisdictional entitlements came with much less well-defined conservation and management obligations. Again, states arguably have tended to grasp the entitlements while sometimes forgetting about the obligations. But as maritime states were trying to maintain a balance in a rapidly changing environment at that time, the convention did impose, I think in response to the efforts of distant water fishing nations in particular, an exploitation mindset, one could say. Article 61 of the convention provided that the coastal state shall determine the allowable catch of the living resources in its exclusive economic zone. And the coastal state, although it is to ensure proper management and conservation, and that there's not an endangerment of the resources by overexploitation. Nonetheless, the conservation measures under 61.3 were also to be designed to maintain or restore populations at levels which can produce the maximum sustainable yield. A notion derived from biological theories of the time, that you could produce a number for a stock that would be predictive and give you the maximum sustainable yield that could go on and on over time. But even here, the principle was immediately gutted by allowing it to be qualified by relevant environmental and economic factors, including economic needs of fishing communities. So in other words, we're going to take a biological concept, an MSY, and allow you to qualify it based on what you need, which is somewhat like saying, well, 2 plus 2 does seem to be 4, but I'd rather it was 5, and go on that basis. It also provided in Article 62 for the promotion of the objective of optimum utilization, was to be the objective, trying to get away from the idea that any state might pursue primarily conservation objectives. And in addition, the surplus allocation obligations were included, the notion that having determined their total allowable catch based on these principles, having determined their own capacity to catch it, states were under some kind of obligation to allocate the surplus. Now, I think those obligations were effectively nullified by the provisions of Article 62, which allows such a wide range of management restrictions that you could eliminate any fishery, and in any event, the provisions were removed from, or actions under this heading were removed from the purview of the dispute settlement provision as well. But the characteristics in general, I think it's fair to call this an exploitation-oriented approach, trying to push that as the objective that still survives in some of the older regional fisheries management organizations. But it also enshrined a particular scientific methodology based on total allowable catch, maximum sustainable yield of the time. It was theory, the methodology that was applicable or available at the time, while simultaneously neutering it, even if you believed it worked. The inclusion of things like other economic factors effectively removes the biological consistency of any such measure. Now this approach was also intended to be predictive in its orientation. And this, I think, reflected developments that had occurred in developed industrial fisheries in developed countries. And in some ways, at least one historian has argued, was much of the reason for the development of MSY and total allowable catch ideas was the need to provide an industrialized fishery with some kind of quasi-guaranteed future interest in a fishery, which essentially allowed the monetization of that future quota or whatever you called it in a jurisdiction. It was hard, as we learned in Canada certainly, though not impossible, to take that away once it was given. But it was necessary to a capitalized industrial fishery that needed to project into the future. You needed that predictive orientation, whether it was actually feasible, realistic, or not. And I think you could argue that there was limited concern shown in these provisions for the principles of management that emerged in the UNCED era later. Now that's a very broad summary, but I'd like to turn to more recent developments, and this is still, much of this is speculative, we'll say, drawing on the fairly limited work of the Intergovernmental Panel on Climate Change as it relates to fisheries. You would expect there would be more of the work might move in that direction, but FAO has filled in some of the gaps. First, there is the question of the carbon footprint of the industry and the relationship there, not a significant part of what we're concerned about here. But the impacts, as identified by the IPCC and FAO, include what they call indirect effects, things like the increasing prevalence of extreme weather events, development of local coastal erosion, habitat destruction, socioeconomic effects related to employment, food security, and the like. And we're going to focus on more ecosystem impacts, effects that have more direct implications for the management of the fisheries and possibly for the legal structures within which that management takes place. Now, for some impacts, as identified out of the sources for this are the adaptation report, as number 5 of the IPCC. But for some impacts, many adaptation measures are going to be determined primarily outside the fisheries management regime. So, for example, we have here that one of the risks that's identified is coastal inundation and habitat loss due to sea level rise, extreme events, and the like. The adaptation includes reducing other stresses, mainly by reducing the pollution, limiting pressures from tourism, fishing, potentially, as part of it, and physical destruction. But it's not actually a fisheries management solution beyond perhaps the reduction of the pressure. It's part of a broader scope trying to, not to fix the problem, but to adjust to it as best as possible. The ecosystem impacts that are predicted, and in some cases people would argue already occurring. I should mention at the beginning of this section I did refer to acidification, ocean acidification in brackets. Primarily these reports have dealt with the climate change, but acidification is a huge part of that as well, and to some extent we can consider the two of them side by side. The ecosystem impacts include things like redistribution of species. The range of species may change. Increasing problems with invasive species now capable of operating in a particular area or thriving successfully in an area, and alterations in disease vectors, the kinds of diseases that species may be subject to. Changes in fishery productivity over shorter periods of time potentially. The expansion of oxygen minimum and truly anoxic dead zones, there's been a lot of research. And again, the acidification impacts on local habitats and species may be quite variable on a geographic basis. That is, these are not necessarily global effects that can be responded to with the same tools in every location. This indicates with the green and showing from the green up through the heavy blue the possible increases, and on the other side the yellows and the reds and decreases in maximum catch potential for a number of species based on potential shifts in climate. That species, as they put it, species richness and fisheries catch are projected to increase on average in mid and high latitudes and decrease at tropical latitudes as a result of climate change. This coupled potentially with species by species productivity impacts based on physiological factors, simple tolerance of temperature change, which can lead to plus or minus impacts on productivity. Spawning issues, time of spawning, that is when spawning will occur and how that relates to the productivity of the species, egg size, survival rates as well. And recruitment. Recruitment rates, which are related to spawning, but not entirely. They can be affected by time of spawning, but also, but directly related, the food availability at that time. And these combined effects can be critical to stock assessment for some species, and the stock assessment, your assessment of MSY and your total allowable catch, are based very heavily on your assessment of productivity for the species. And it comes as well, both FAO and the IPCC, with a couple of reminders. First is that climate change is just an additional factor in some ways. It adds, as they say, to the threats of overfishing and other non-climatic stressors, which, in a wonderful understatement, as they say, thus complicating marine management regimes. So it's not as if overfishing and habitat destruction from fishing effort is going away while the climate change impacts are occurring as well. And second, simultaneous drivers, as they call them, such as warming and ocean acidification, lead to interactive, complex, and amplified impacts for species and ecosystems. And I think what they're getting at here, and whenever I see the terms interactive, complex, and amplified all in one sentence, it's an indication that scientists aren't ready to say, because it's too complex, what could occur and how fast these things could occur as a result of the combination of these factors working together. Now, those are my sad attempt to try and reflect some of what the scientific debate is going through at the moment. But this has direct impacts on how we've set up legal and management structures as well. Species redistribution, for example, leads to, potentially, incompatibility of very much species-centered RFMOs, regional fisheries management organizations, where the geographic limits no longer track the species range, or may vary significantly. So the reliance on existing RFMOs in the post-UN Fish Stocks Agreement in the 1990s have been the primary management structure for getting at fisheries that exist either partly or completely in the high seas. It's either as highly migratory species or straddling stocks. The reliance on the existing ones in the face of newly feasible fisheries may cause problems where those fisheries are beyond their jurisdictional reach. And the opening of new areas, such as the Arctic, parts of the Arctic, for example, with unanticipated, potentially rapid fisheries development, where there is no RFMO or other management authority, and where in past experience it can take quite a bit of time to get one. These can lead to sudden and difficult problems. We also, and this is a purely nostalgia here, we have Canada's brief moment of martial glory on the high seas. It's the Esti from the straddling stock dispute with Spain and the EU in the early 90s. The Right Honourable Brian Tobin at that time was the fisheries minister. And a very direct conflict over straddling stocks, conflict that mirrored what was going on in other areas. I had worked just before that period in the South Pacific, where the similar types of conflicts occurred, but with respect to highly migratory species, of course, with tuna. But now we could be facing the emergence of new shared stocks, new straddling stock situations as well, and shared stocks where there are two jurisdictions involved, with new potential conflicts emerging in perhaps unexpected areas. And there may be, again, early to say, but there may be deeper structural issues around the capacity of the current legal structure, as we set it out in the Law of the Sea Treaty, to adapt to the new issues. And here I'm thinking particularly of the issues arising from climate change, but it can be applied more broadly than that. The IPCC and FAO, I think, had a limited focus on governance issues and what they were dealing with in fisheries, to the extent that they've dealt with the climate change impacts in fisheries. But they did identify that addressing the complexities of climate change interactions requires what they call mainstreaming cross-sectoral resources, cross-sectoral responses into governance frameworks. That takes us back to the notion of the sectoral divisions in the Law of the Sea, reinforced by things like the UN Fish Stocks Agreement, regional fisheries management organizations are regional fisheries management organizations. The climate change is dealt with somewhere else. To some extent, ecosystems are as well. To date, we have seen some ability to make those crossovers. The MELAW regime in the Antarctic, partly because of the limited number of states with some real leadership from certain parties, they've managed to interact fairly successfully in some fronts between the fisheries regime on the Living Resource Treaty and the environmental regime, things like the Marine Protected Area programs, and to cross-fertilize across those two regimes. Likewise, in the Northeast Atlantic Fisheries Commission, NEAF, cooperation with OSPAR, there have been sort of glimmerings of making this cross-sectoral response possible, even though we don't have a firm institutional basis within which it happens automatically. It needs to happen and has been identified as one of the critical needs. The other point made, and it's an FAO study in 2008, is that governance aiming towards equitable and sustainable fisheries, but must accept inherent uncertainty, first of all, and should be based on an ecosystem approach. Something that we've struggled with for years, at converting this broadly defined ecosystem approach into management measures. But it's thought, as FAO puts it, that this would improve the adaptive capacity of fisheries, that getting away from purely productivity, exploitation-based measures of managing the fishery and recognizing the uncertainty, which if you think back to MSY, is based on a pretend form of certainty, even though the scientists know full well it's uncertain, and trying to move to accept a system that builds on more than just the current exploitation rate out of a fishery. And many states have tried to do that with things like area closures and MPAs and the like. But those principles and other post-UNCED principles such as precaution or even more broadly sustainable development have been difficult to apply in RFMOs. You look at the current experience in the Commission, ICAT, the Commission for Atlantic Tuna. The difficulty in getting acceptance in the convention of some of these provisions, principles, have been very, very surprising, shall we say. And the question is, how far have we really gone? How well has the law of the sea structure accepted and incorporated these principles at a level of reality? Now, one example cited quite enthusiastically and was met with a good deal of excitement, and to some extent justified, was the introduction of the precautionary approach in the UN Fish Stocks Agreement, which dealt with highly migratory species and straddling stocks. But I encourage a little bit of skepticism about the reality of that. It's true that the Fish Stocks Agreement was clearly a post-UNCED agreement. Article 5 of that agreement gives you a list of management measures and principles to be applied, not just measuring the catch, but management principles. And they included, among others, precaution and protection of biodiversity as things to be applied by states in the management of these fisheries, not explicitly provided for with respect to those same states in their own zones dealing with stocks that are not subject to the UN Fish Stocks Agreement, which leads to a certain amount of skepticism right away. But beyond that, even in the Fish Stocks Agreement, after that reference to precaution, for example, and protection of biodiversity, in a non-hierarchical list, you also have that management measures shall promote the objective of optimum utilization. Mortal words of Casey Stengel, deja vu all over again. You also have measures to be designed to maintain or restore stocks at levels capable of producing the maximum sustainable yield. Again, as qualified by relevant environmental and economic factors, as if you can qualify it by those. And the precautionary approach is to be applied, leaving aside that we now have the main principles from the Law of the Sea Convention brought forward. What does the precautionary approach mean in the treaty as this new agreement as negotiated? Well, it's to be applied as defined in the Fish Stocks Agreement in Article 6. I don't need all these to be read, but in brief. Article 6.3 says you apply the guidelines set out in Annex 2 of the Fish Stocks Agreement, and you determine stock-specific reference points and actions to be taken if they are exceeded. Now, the requirement that you take action in certain cases, you must take action, is in advance. But we have to consider what these reference points are. A precautionary reference point is, as they call it, an estimated value derived through a scientific procedure which corresponds to the state of the resource and of the fishery. So the resource and the fishery, again, integrally connected. States are going to use both conservation or limit reference points, which represent the outer limit of the biological parameters that you've identified for the species, and management or target reference points, which sounds an awful lot like what used to be done with set the maximum sustainable yield and set the catch a little bit back from it. This is starting to look remarkably analogous. Management strategies, this is all from Annex 2, are to seek to maintain or restore stocks within the agreed reference points. Forcing states to agree on the reference points in advance is an advance, or an improvement certainly, and should include mechanisms to trigger pre-agreed conservation management steps. But the management strategies are only to ensure that the risk of exceeding the limit reference points. Remember, the limit reference point is when you have reached the biological parameters, essentially. To ensure that the risk of exceeding the limit reference points is low, very low, and that they are not exceeded on average. Not that encouraging for people who are familiar with the concept of an average and what happens when you exceed the absolute limit point you were prepared to set for a species when, if you are unlucky, exceeded a couple of times even. And come back to that in the notion of rebounding stocks, which seems to be built on the notion that the stocks will rebound after they have exceeded those levels. Now, the level of fishing mortality, which generates MSY, should be regarded as a minimum standard for limit reference points. So at least it's not the maximum, but it's the best it's the least you should be prepared to put in for limit reference points, which, in other words, starts to mean that precaution, as it's defined in this convoluted definition spread over a number of provisions, starts to look an awful lot like a properly managed total allowable catch MSY system that you were supposed to be doing anyway under the law of the sea regime, once you get through the definition. That leads to a certain amount of concern that the reality of the adoption of the unsaid principles has not been what it should be. Now, I'm focusing admittedly on a narrow range here, and there are certainly, even in the fishery side, there are other developments through FAO policies, improved national policies, a number of regional initiatives that have gone beyond this in other ways. That is still there. But the legal arrangements, as put here, have shown a remarkable resistance to adaptation. So what might we take as a few lessons going forward from this, apart from the fact that a lot of this has been speculative? The first, it'd say, do no harm. I would argue, and I think there is historical evidence for this, that the total allowable catch, maximum sustainable yield approach to fisheries management arguably had diverted, over the 1970s and 80s, diverted scientific effort away from understanding the biology of species, from understanding the ecosystems, to feed what I call the insatiable maw of stock assessment. That is, those scientists who are prepared to provide the data, and of course data costs money to collect, would be the ones who could provide the government with the answers that they needed. And there's an argument that the Law of the Sea Convention, if the fisheries provisions had actually been faithfully executed by many, many states, and many, many states simply did not. I worked throughout the South Pacific in the late 1980s into the early 1990s, and many states were absolutely, it would be impossible for them to have devoted the kind of effort to systematically apply the kind of scientific methodology that was required under the Law of the Sea Convention in their national fisheries. But if you had, there'd be an argument that you were putting your limited research dollars to essentially repeating the same thing over and over again rather than to developing new knowledge about how fisheries really should be managed. Coupled with this, I would suggest, is that science and hubris can go together, particularly with the problem that the negotiators, lawyers, diplomats, and the like may not fully understand what they're being given by the scientists, of course. This is something that people like Art Hansen and Edgar Gold and Doug Johnson certainly beat into our heads early on, that this was that we had an obligation to try and understand the advice we were being the advice or the information we were being given by other disciplines, whether it be people in the shipping industry. I still remember the collision and salvage course run by Edgar and Norm, where we were expected as students to find out what a bunch of crew members on two mythical ships, represented by students at the Nautical Institute who were in training, what had actually happened, and discovering that we had to try and understand what they were telling us. And this applied just as well in the fisheries management context as well, that we have an obligation to understand the interdisciplinary context because of this. Here, the permanent enshrining of a particular approach would suggest that you aren't taking account of the fact that science changes. The science of the day is not going to be the science of tomorrow. And to permanently put in a treaty, which is virtually impossible to amend, not just broad principles, but today's particular theory of management or management technique, causes real problems. There's a better way to do it. Next, more law is not always the answer. Much of what needs to occur is in policy development, and the notion of binding agreements, which I found over the years, for example, that NGOs tend to be very keen on getting binding international agreements, which are in implementation not as significant as they hope they will be. That the bindingness sometimes is very significant, as with jurisdiction and the like, but sometimes it's less significant than political will. And political will will be critical in cases where we have not fully implemented the obligations that we already have, which you could certainly argue is the case with many of our fisheries obligations. With respect to adaptation, and particularly this is, I'm just using the example of the climate change material I talked about earlier. The Law of the Sea system, the Law of the Sea 1982, as I said, is based on the notion at its heart of an MSY, the notion that you can model based on historical data and predict what's going to happen. In fact, it directed at prediction to a level of detail, and some would suggest is not possible, even at its best, but which may be even more problematic now, that the historical data in which you've developed your predictions of the future may be rendered useless by some of the impacts of climate change, which may not be able to be applied globally because of the localization of the impacts that FAO and the IPCC have predicted. And in an environment, in a system that is becoming less and less predictable, a management approach based at providing predictability to the industry, largely for financial factors, I would suggest, is a problem, and one that we may need to rethink. And this, and I realize I've gone over time as always, but I'm assuming that can be edited, might lead us to consider a few issues with respect to the value of permanent legal arrangements. What should be in a permanent legal arrangement, and what should be in other forms. And things like the Montreal Protocol dealing with ozone, and the ability to make changes as time goes on, are different ways of doing this. Would suggest that many of the agreements that IMO deals with have recognized this, that there are things that are permanently part of the legal arrangement can only be changed with renegotiation of the parties, like the entire Law of the Sea Convention. And there are other parts that can be done through various processes established within the ongoing operations of the organization with the participation of member states and others. That's a different way of approaching it. Where do we think the value of having things firmly established in a permanent legal arrangement is better, and where can we leave it to some other process? It suggests that there's a very high value in establishing jurisdiction in a permanent legal arrangement, the kinds of conflicts that emerge from controversies over who has jurisdiction over what and where requires firm and predictable legal settlement, and certainly continuity and certainty are at a premium, as reflected in the general approach of international law to borders and boundaries, that they are the ultimate dispositive treaties. So it made sense in some ways that once we started with the jurisdictional parts of the Law of the Sea Convention, as it was concluded in 1982, that the addition of things into the convention beyond those provisions would be seen that having it in the convention was very important to do. But I think this becomes problematic when you're trying to render very changeable science, and there's nothing scientists like better than destroying the existing theory that's been dominant and showing that you've got to move on. That's part of the natural process of the scientific method. But to put the specifics of the science as a permanent legal obligation rather than in some subsidiary form or process is problematic. We don't just see it in the fisheries context. I would suggest that the outlandish provisions of the continental shelf outer limits in Article 76 also reflected a best guess based on the science of the time, which turned out to create enormous headaches for the Commission on the limits of the continental shelf and everybody else, turned into become something much less simple than what was anticipated at the time. It could have been done differently. It suggests perhaps a different approach to treaty negotiation for future arrangements related to, here I'm talking primarily about fisheries, and I think to some extent you have seen that in instruments like climate change, despite the problems. The other thing that I come back to, and I think it's hugely true in IMO and FAO and elsewhere, and it's something that Doug Johnson and others, at the time I started as a student to bring this back to where I began, were immensely clear in their insights on this, was that this type of law, this broad-based international management for something more than simple conflict avoidance, that institutionalization plays a critical role, that without vibrant and effective institutions that can advance, continue, and manage the law itself over time, all of the best intended legal arrangements placed in a binding multilateral treaty are likely to come to very little. So I will end with that, and thank you for your patience if you've made it this far without rolling ahead too fast. And again, I'm going to take that one last opportunity to thank Doug, and Edgar, and Norman, and all of the associates and students, graduate students at the time, who welcomed me with such open arms into that institution at that time. And it's a great pleasure to come back here and reflect a little bit on it. Thank you.